the topic of today, that is Commercial Codes Act. With that, I ask that you give your full attention to Sir and help me in welcoming Sir for the webinar. Chandhiok, sir.
Thank you, Tarveen. Thank you, Govind. Thank you, Janvi. Thank you, participants. A wonderful good afternoon on a sunny, bright day. Contrary to what predictions show that probably there'll be raining day today. But the very fact that you are assembled and this joint venture between Janvi and Tanveer and others are bringing out you on a Sunday afternoon shows not only the organizers' commitment to the cause of justice, which is fundamental and constitutional ethos of our Constitution of India, but shows your commitment to be a part of this and to give me this great honor to be amongst you. Feel young, feel good, and feel that I'm back in the fraternity, notwithstanding these trying times. Let me also put a prayer for all of you and your families, that notwithstanding there's an increase as we see every day, and India, though on a wrong front, is on the top every day, but we pray that each one of you, each of your families, well-wishers, friends, acquaintances, remain happy, healthy, and rise to the occasion to see this and face this unprecedented challenge. You all know that Commercial Codes Act was brought in 2016, but many of us who came to the bar earlier in point of time, only by virtue of age, not by virtue of knowledge, is that under the Punjab Codes Act, which was applicable to Delhi or the Union Territory of Delhi, we also had a commercial court in district courts. And one had the honor to appear and privilege to appear before the Honorable Commercial Judge, even when there was no commercial court. However, the commercial court was brought in as we found that there was foreign investments that were involved. There was a cross-border situation that were coming. Commercial matters were from north to south, east to west, and you are extending your arms in exports and imports from United States on one side and Japan, Australia, New Zealand on the other. Therefore, and one of the grievances with the foreign community probably was having against us was that there is no time duration or courts are taking too long in dispensing justice. Let me share with you all two anxieties that I have on this issue before I go to the Commercial Courts Act. Those, I'm just digressing with your permission. I think we should all be proud of the fact that notwithstanding all these present times when Supreme Court has not stood up to the constitutional values, time when we are looking at our courts to bring access to justice in a better form, notwithstanding all those grievances that we have. But we should be proud as Indian to have two things in mind. One, that people in India still believe in rule of law, and that is why people are knocking the doors of the court. They are not bringing something which is totally unprecedented, which are many other parts of the world that you see today, notwithstanding that they feel that they are developed words, etc. And let me also share with you the number of honorable judges that we have, the per population that we have in this country. Each one of them is doing a commendable job. And that commendable job is only possible when there is a bar to assist them in dispensing justice. So the credit of justice delivery system, notwithstanding the charge that some time is taken, is actually goes, and we must all wear that crown together with the judges to say, we still continue with our constitutional values. We still continue to bring that access to justice to a common man. And we are striving both at bench and the bar to reach to that occasion. Coming back to Commercial Courts Act, I thought it was a step that was required. And the government and the legislature thought it must bring a legislation to give that strength to its ease to do business, the one of the policy matters of the present government, and certainly it has paved a way with respect to that. And all our litigation with respect to intellectual property, with respect to commercial property, with respect to commercial matters, commercial contracts, whether it was arbitration, it was non-arbitration, comes within the scope of the commercial law. And commercial definition has been defined in the statute. It includes everything possible that we can think on commercial world. Therefore, the ambit of this act is completely to bring into its fold all commercial activity so that the commercial activities disputes get resolved first. And I see the first, though the amendment came in 2018, but it looks to me the thrust of the matter is that in a commercial matter, an attempt must be made to resolve the dispute first. Because in commercial matter, time taken even to bring to a litigation, even if we fast track is as per the new provisions of law and the amended CPC, still it will take some time. So there a mandatory section 12A was brought in by an amendment in the Commercial Courts Act, which mandates today that we must have a mediation before we start the court. Though there's an exception, which is more abused by all of us rather than followed, because with every suit we file an application and fee there's an interim order. But having said that, there are matters, there are cases which have gone to mediation. And I'm proud to tell you, as part of a mediation family, that we have succeeded in 62% of the matters that came in mandatory pre-litigation mediation. Thanks to all our mediators, thanks to the efforts that they are making, thanks to Samadhan, which is part of the High Court, Delhi High Court, and many more mediators who form part of Madhyam or otherwise, who have been instrumental in bringing these situations. And when the courts were closed, I thought I want to bring this to my leaders' notice, that to my personal knowledge, many matters came to mediation, even if I don't call them formally mediation, came for reconciliation, restructuring, or reconsideration of their contracts. In many matters, I have been involved to see only a force majeure clause gets amended, because force majeure, nobody thought COVID would get included into it. So we renegotiated the contract in terms of felicitating renegotiation between two parties. Because the first principle of mediation is you're empowering the parties to resolve their disputes themselves. So the submission that I'm bringing to your notice is that it is not that COVID brought any impediment in the functioning of a resolution process under the Commercial Courts Act. I'm conscious I don't have the figures, but I'm sure you all can judge that from the website of Madhyam, of Samadhan, as to how many matters came, because the Legal Services Authority is the authority under the law, which is where you have to approach for the commercial matters, and which in turn goes to Samadhan. But these are matters in insolvency, matters who are pending in arbitration, matters which are pending adjudication in many other tribunals like TDSAT, etc., were not concerned, really speaking, under the Commercial Courts Act. It's not a civil suit. Yet, those matters came to be resolved during this COVID period. So, first principle that we must learn from this commercial court is that commercial values, commercial contracts between the parties are extremely important. Therefore, for us to look at, as lawyers, what is commercial, we must go through the provisions of this act to see how best we can utilize these provisions for the purpose of expeditious disposal of the cases. And during this COVID, having put a very straight question to me that should you, as a lawyer, as a senior counsel, change your attitude towards litigation? And the answer was yes. If in a matter where I'm briefed, if I find out of 20 issues or 10 issues or 5 issues, 3 or 5 can be resolved by resolution, then I should offer that in the court. Because for 2 reasons, I'm submitting this. Section 35 of the Code of Civil Procedure has been amended. So if I give a reasonable offer to the other side and the other side rejects it, then the cost, notwithstanding that he succeeds at the end of the day in adjudication, the cost of my litigation would be borne by him as long as I was reasonable, and the judge finds that position. So it's important for us to understand the stages where we are looking at our commercial court. First is, am I a commercial dispute? Is the first question that I must answer. Then I must know, in fact, to be on a lighter vein, I must tell you all, when Delhi Rent Control Act was amended and we brought a chapter by which we were seeking leave to defend under section 14(1)(e), capital A, capital B, capital C, matter was challenged because the leave to defend application of the tenant said, I deny Mr. Chandhiok is son of Mr. S.S. Chandhiok. So the question was, what kind of affidavit should be filed? Therefore, I'm taking that clue into it. Justice Tipal had looked into that part, and Justice Yogeshwar Dayal, his lordship then was, has looked into that part. But that's not the issue that I'm raising. I'm raising an issue that once I see my facts, I must see whether it's a commercial court or commercial dispute or not. Once I come to the conclusion that it's a commercial dispute, then I must disclose all material facts, because I have to get my client to file an affidavit in the format provided in the statute, which would also disclose to the court not only documents that are in your power and possession, but even documents which may go against you. So the first art of a commercial lawyer, in my humble submission, is you people must examine, put everything on record, and take your case out of it. That should be the first art in a commercial court that we need to look at, and from Commercial Courts Act also. Having said that to you, we have to consider what kind of affidavit am I filing. I must disclose to the court that a particular document is not in my power and possession, if there was any negotiation between the parties. And here comes the crucial part now. If pre-mediation under section 12A is mandatory, am I supposed to disclose what were the parties' negotiations? Am I bound to disclose what was exchanged with the felicitated mediator in place? What documents were exchanged? What else came into my knowledge, which probably I did not have prior to raising this dispute before the mediation? The answer is no. Therefore, your affidavit has to be very clear that though I had gone into mediation, but the mediation proceedings are confidential, and to that extent, I am entitled to retain that confidentiality and not disclose that in the present litigation. These are some precautions, because I'm looking at it from future for our young friends. As the world is growing, I find more commercial disputes will arise. There'll be more rights involved. There'll be stakes may be higher, maybe lower, makes no difference. It's the principle of law that we need to decide. And on principle of law, we must maintain that confidentiality, because the first principle, first fundamental principle, if I can say that, of 12A would be that the confidentiality is met, and that is provided in the rules, provided in the statute. And I hope the next few months before we even end with COVID-19, probably a mediation act would be in place, and we'll also have the benefit of looking at that act, which will be read in conjunction with the Commercial Courts Act, to see how do we take this resolution process forward. So the two turns that take place as a commercial lawyer would be that first I have to see it's a commercial dispute. I must see whether it gets attracted under the Commercial Courts Act. And the Supreme Court, with all humility at my command, when it came to a commercial property, the Supreme Court restricted the interpretation of this commercial dispute to say only if the commercial property is ready. Now, if the dispute itself is with respect to the delay in making that available to me, then I'm sure it's a dispute within the meaning of the Commercial Courts Act. I don't have to trouble myself to go to consumer forum or to go that, because most of us feel that commercial courts is one remedy. I have an equally efficacious remedy under the Consumer Forum Act. And now, in fact, under the RERA, where we find there's a tribunal constituted also. But to me, a commercial dispute must go to a commercial court. And when the commercial court, the Supreme Court, with all humility, as I said, was wrong in saying that the right is restricted as a commercial dispute. The right must be in relation to a commercial property, fine. But as long as the dispute between the parties or the issue to be decided by the commercial court relates to a commercial property, it will still be a commercial dispute, in my humble opinion. But having said that, you cross your first threshold. As I said, your plaint must have all those particulars. You should be careful. We should be careful in what we are filing as an affidavit in support of our plaint, because I do not know, time may one day, after especially the judgment of Mr. Prashant Bhushan, it may be possible that the judges may take a view to say that your affidavit is false, and consequently you totally downtrack your whole litigation and go into a different sphere. Therefore, we should be careful. We all must take care in what we are filing in a commercial suit. That brings me to the second stage for the defendant, which is a written statement. We thought that the Order 8 was interpreted by the Supreme Court to say that it is directory, it's not mandatory. But now the law has been changed after interpreting the Commercial Courts Act. Therefore, the jurisdiction after the time limit provided in the Act is taken away and will not be entitled to. I'm not taking COVID position into consideration, because COVID had put to standstill all kinds of limitations, including, to my mind, under the Commercial Courts Act. But if there was no COVID, then there would be limitation on the rights of jurisdiction of the court to allow written statement after the statutory period has expired. But the question still, probably the court will have to answer that question, that if the word in Order 39, for example, is used as suit, and I filed my response to Order 39, Rule 1 and 2, and that defense is available to me, and I'm only bringing that defense, and I would probably make a statement if necessity comes that to say, read my reply to the Order 39 to be a written statement, which I filed well within the statutory period. What will be the effect? I leave it to my friends to answer that in an appropriate case. Because normally speaking, we all understand that it's an interlocutory application of Order 39, Rule 1, 2, and 3. And if there's a violation, I bring 39(2)(a). But to me, Order 39 is talking about where the court in a suit finds it appropriate to pass an order. So the word is suit, and suit can't come, because there has to be a plaint. Plaint must be registered as a suit, then only there can be a suit. Therefore, actually the judge is passing the order in the suit. Interlocutory order is merely, or interlocutory application is merely for the purpose of convenience of the parties, or convenience for the judge to have an interlocutory interim relief to be granted to you. Those of you who have seen, I'm sure most of you have done that, practice in the Supreme Court, for example, when we file an SLP, we don't file a separate application for interim relief. It is in the same special leave petition we seek an interim relief. Therefore, actually, it is the constitutional remedy that you're invoking before the Supreme Court. And in that very jurisdiction, you're asking the Supreme Court to pass an interim order. Having said that, therefore, the question would be, should your affidavit under Order 39 should also be a complete affidavit to my mind. Though we have accepted in principle that if I say averments made in the plaint may be read as part of this affidavit, it will suffice. Yes, there is a view with respect to that. But if you go to original side of Bombay, Calcutta, Madras, there you file only an affidavit, and that affidavit itself is like a plaint. And till we brought in Commercial Courts Act and we brought these time limitations, my experience of Bombay, for example, is that the suit was lingering on for 2 years, no written statement used to be filed. 2 years, maybe more sometimes. So this was one of the grounds which the foreigner investors were taking in our country to say our disputes take longer. And that's why probably the legislature thought we must bring a timeline with respect to the same. And let me compare this with you today in another position, that is IBC, insolvency, which also came in 2016. The legislation almost at the same time, wherein also timelines are provided, both by the legislature and by the regulations, where you have to submit a resolution process, and the resolution process is not passed in section 3031 by the NCLT or the adjudicatory authority as it is called, the liquidation must follow under section 33. Now this is also for the first time that such a legislation has come which provides for timelines. Therefore, the first discipline that we as lawyers have to bring in now, how do we maintain these timelines? Of course, COVID exception, I'm not addressing myself to that I've already said, by an order of the government, the order of the Supreme Court, order of the High Court, everything has come to a standstill till we back to the normal situation. But as a commercial lawyer, we have to also see where did the court has now amended the Code of Civil Procedure. The Civil Procedure Code has been amended by virtue of these provisions of this Act. The mediation rules are also provided under this Act. Though, as I said, once a mediation Act comes in, what is the effect of that would be seen once the Act comes into play or an ordinance is brought about. But if the Parliament is going to start on 14th, I expect the legislation, if the government is very keen on mediation, especially in these times, to probably bring a mediation legislation soon. I thought somewhere in one of the webinars dealing with something else, a question was put to me that if there is a mandatory mediation in 12A under the Commercial Courts Act, is there a bar in the court looking at it subsequently? And I had said no. It can be at any stage of the proceedings where the court finds there are issues of settlement between the parties, or court, even while framing issues, find that at least these 2-3 issues can be resolved between parties. It can always send parties to mediation. And I don't think there's any bar in the statutory framework of the Commercial Courts Act not allowing it to do so. However, the precaution that one needs to take is in a commercial litigation is you must prepare yourself with what evidence would you like to lead. Normally speaking, we file our written statement, we file our replication, issues are framed. Then we think, oh, whether A has to be examined or B has to be examined. But in a commercial litigation, to my mind, we must look at it when we are drafting our plaint or written statement, as the case may be, because both are pleadings after all. Replication is not provided in the statute. It's only an additional written statement or additional statement on record. But that's question is, when you are before the court, if you know what evidence you are going to lead at the time of framing of the issues, or what evidence of the other side or yours is against you or for you, as the case may be, you'll be able to assist the court better to frame those issues that are really required for adjudication in a commercial dispute and not raised. In fact, it reminds me, we had a very honorable judge who went to the Supreme Court, Justice Vaishudayal, and we lost him in the office, one of the honorable judges who passed away when he was judge of the Supreme Court. When he was sitting on the original side, and I as a defendant would say, please make an issue, the plaint is not signed, verified, and suit instituted by a competent person. And his lordship would say, I will frame it since you're saying it, but I'm going to put a note on it below. If this issue is decided against you, the cost of the suit will be borne by you. So many of us used to not press it because either the power of attorney or the resolution was already on record. And in any case, under the CPC, a principal officer can always institute the suit and sign and verify the claim. So having said that, we need as lawyers to update ourselves. First, master my facts of the commercial dispute. What is really the dispute? And to my mind, I must as a lawyer also examine what is the underlying dispute. Sometimes on record, you find something else, but underlying there's something else. So if you go to that underlying dispute, maybe you are able to utilize your negotiation skill, your technique as a lawyer, your technique as advocacy skill to bring on record what really would be disputes in a commercial matter. Because timelines are important to my mind. And if we are able to maintain those timelines, we'll be able to satisfy the test in the international market that today we are doing. But I must share that with you, notwithstanding that Commercial Courts Act came in 2016. In New York, a litigation was initiated where question was why delays take place in Delhi High Court. And the plaintiff there was alleging that in Delhi High Court, a suit was pending for over 9 or 10 years and trial was still going on. And both sides filed their experts' evidence before the court. And I happened to be the person engaged as an expert for the defendant. So I was able to place before the court evidence from Delhi High Court with statistics that there were many suits that have been disposed of within a span of 6 months. So do we understand there's some cases because of the exigencies of facts of that case, legal or factual issues that may arise, may take longer. And after all, the court has limited time at disposal. And we lawyers also have limited time at our disposal. We would like to do the best. But having said that, still there were cases after cases which the court has disposed of in Delhi High Court in 6 months' time. And I think the New York judge returned that plaint at the end of the day to say these statistics show there's no delay in the matter. And I had in fact cited there a provision, a case instance in England where I had the privilege to appear as with the solicitor. Of course, there is the Queen's Counsel leading us in the matter, where we found that the UK court had taken 1 year and 9 months at the first instant to decide an application for leave to defend fact. So I said, we are looking at other courts, but please look at this part. So it's not that in commercial matters or matters, there's an expeditious trial or anything. The leave to defend itself was decided after 1 year and 9 months. So please don't take those views in consideration when our WhatsApp messages or other messages that come to us. Oh, there's a lot of delay. People talk everything. In fact, I find in foreign media or in foreign circles, every time we are only criticized for delay. There's no other criticism. It's not that my quality of justice is bad. It's not that the assistance provided by the courts are bad. And we had the privilege to, the High Court Bar Association, to file that petition of Court Fees Act, which won in 2012 the world recognition of the best, one of the best judgments of any court in the world, Justice Geeta Mittal's judgment. So therefore, please look at it from, therefore, we need to train ourselves. And I must congratulate the organizers again with respect to the fact that you're giving us all opportunity to interact for looking at things in a fresh matter, looking at things in these COVID times and see how do we enhance our knowledge. Coming back to the Commercial Courts Act, when we reached the stage of Order 15, and as I said, the jurisdiction of the court to frame issues always there in respect of even CPC. But here the court can always even pass a decree with respect to where the court finds there's no defense actually raised by the defendant. That's a departure made. Though I personally feel even with respect to an ordinary civil suit, the court will be entitled to pass a judgment if it finds the defense is without any merit or defense has no evidence in support of it. Because we must look at whatever we plead that there's evidence to support it. What is the sufficiency of that evidence? I'm not disputing that part. That's a question to be interpreted. That question is for a witnesses to depose. But as of today, I feel it's time for us that we must look at our evidence at the time of framing of pleadings, because that will assist the court at the time of framing of the issues to show what documents are admitted, and therefore on that admission alone, no trial is required or trial is only required in one of the two issues. It reminds me of Justice Pradeep Nandajog when his lordship was in Delhi on the regional side and had sent for me as the president of the bar to say the time has come for you to see how evidence by way of affidavit has to be filed. And we did, after that, did 3-4 seminars, not webinars. At that time, there was no webinar in place. So we took advantage of that situation. 3-4 times we had senior people, both on the criminal side and civil side, to come and tell us what should be the affidavit of evidence. The experience tells us we normally just take the plaint, take our computer and cut, paste and do it. That's not the evidence, my dear friends. We must look at as if I am making that statement in court on oath and I'm actually physically present in court in making that statement. So once we are able to do that, it will be worthwhile for us to exercise our acumen to see how best we can look at it. And many times I find the documents have not been even proved in the fundamental principle. But in a commercial court, unless the document is specifically admitted, we must make it a point to prove that document. Now, proving of the document could be, if I am the author, I am the witness, or if I'm not the author, at least it was in my presence that it was executed. And if it is not, then at least I must be familiar with the signatures or the executants in writing in the normal course of my functioning. As if it's a corporate entity or an individual, supposing the father unfortunately is no longer there, then I as a son would stand up to say, yes, this was executed by my father or not executed by my father, either case. Therefore, affidavit by way of evidence and the evidence recording itself its material. And I do not know whether this dream in my lifetime would ever come back to it. I feel this recording of evidence by local commissioners must be dispensed with now, because that is not the evidence by which people, actually witnesses, have to be recorded. One should, we had made a representation to the government, or to the court, sorry, requesting that we should have, those are who are additional district judges who are coming as joint registrars, should be empowered not as local commissioners, but in their jurisdiction as judges, to disallow a question, allow a question, note the demeanor of the witness, etc., etc. But that is yet to see. I'm sure the present bar association will look into it and probably assist the court in coming to that conclusion. But having not that provision apart, the fact still remains that if we want to do something, and when in 2006 we brought that mediation center into place, many of us thought, including my own self, that probably it will affect our practices. But today, look at the time that we have spent in mediation, how well we have done. It has not affected our practice. In fact, it's helped us to enhance our practice facilities, because if a client comes to the conclusion that you are not a person who creates impediment in the disposal of the case, whether it's by resolution or adjudication, then he would next recommend 20 people to you. Your name would go out, because we can't advertise so far, though we are coming into the international market. Lawyers are looking at it that we should be allowed to advertise like we have in America. But we are not in that sense of the matter. We have been, it's a calling to the bar. It's a calling to the bar that I doubt whether in India we'll be able to have that position where we should be able to advertise. But of course, it's different to say that I advertise that I am a lawyer available with respect to a particular branch of law. It's a different question. But if you say that I am, like, if you ever, those of you who have been to Washington, D.C., I do not know lately because I've not gone last 2 years. But before that, there used to be hoardings that if you have an accident on the highway, please contact Tarveen Singh Nanda. Now, that part is not possible in this country. And I think we must maintain the dignity of this profession. And the dignity of this profession is today, and I said that yesterday speaking at the university, and the question that put was to me, what is the distinction between a lawyer profession and a profession which is equally like doctor, engineer, for that matter, chartered accountant? And I said, the only distinction that I can think of is that I am given a free hand to think. I am given a free hand to speak in the court and to assist the court in doing what? To arrive at truth and deliver justice. So that distinction is only with us as lawyers. And that distinction is more required in the Commercial Courts Act, because after all, in commerce, people are looking at money. And if my money gets stuck in a deal with respect to which there's a dispute in court, there's a business opportunity that a person is losing to invest that money somewhere else. And if he's losing that opportunity, then obviously he would probably feel whether the justice delivery system is adequate to remedy if there's a breach by an Indian party or a dispute with respect to Indian soil. Therefore, we must look at all these situations when we are looking at commercial court. The basic situation, the fundamentals is what I've dealt with. I would wait for your questions if you have any specifics to put to me. But my overall view of the Commercial Courts Act, it's a enactment or a legislation in the right direction. It gives us many new things to look at, so that persons who may say, I've read CPC in 74 or 75 or 72 in the law school and I'm fine with it, or I've dealt with CPC all this while, is not correct. And to make my point, I must give you this example because it's apt for us to look at lawyer on the lighter vein, not that it has any repercussion. An amendment was brought in CPC in 1976. And that amendment, an execution was filed when we had an honorable, very eminent judge who came from district courts. And he passed the order that after the amendment, section 60 C, for example, which safeguards one of my residential houses from attachment, is no longer subsisting because it's an amendment made by Punjab, which was made applicable to Union Territory of Delhi. Another execution petition, it was urged that that has no bearing in the amendment at all. His Lordship felt, yes, the second was not right. So he sends the matter to the Chief Justice to constitute a larger bench to decide this issue. And Justice Prakash and his Lordship then was send the file on the administrative side to say your second view is correct and your first view is not correct. So his Lordship had to deal with the second view. So it's an administrative side where his view was in fact overruled by the Honorable Chief Justice. This is just on a lighter vein to say that the amendments in CPC brought about by the Commercial Courts Act, that's the point I'm trying to make. The new things that they have brought about, for example, Section 35, 15A, Order 15A, all these amendments need our attention very badly. We need to look at them in detail, study that position, and then apply that position. And therefore, while wishing you all well, wishing you, we hope we can see each other physically soon. I'll wait for your questions because I know there's a time that I must look at. I already, I think, exceeded my 30 minutes. But anyways, I have no problem. I can go ahead with it because I feel interaction with you is more important from my own point of view, not only from your part. Thank you very much.
Thank you.
Thank you, sir. Thank you so much, sir. Sir, there are a few Q&A. With your permission, I would like to proceed.
Yeah, please do that.
I would just like to say, sir, amazing lecture, sir. Just so many points are clear. It was crisp. It was right on point of commercial courts, and did address a lot of questions that we as young lawyers have for the new act that has come in, because ever since it's come in, the course of litigation, the way it is practiced, has been changed. So, Your Lordship, without much further ado, if you will allow, I will say. Sir, the point is that do you think the coming of the Commercial Court Act has elevated the stature? Like you said, there is a difference between how litigation is done in India. So, has it elevated the stature of judicial proceedings to an international level? And definitely in your experience as a lawyer and a varied, experience from both sides, before the bench also and as a prominent member of the bar, what would your advice to young lawyers in regard to the free thinking part? Like you said, sir, that the only difference between doctors, engineers, CAs is that we have a free thinking part. With these laws coming into effect, and how we should think as lawyers and change our strategy towards law and litigation, sir.
Well, I have a very personal view on this part, and I feel Indian lawyers by far are the best in the world. When I say lawyers, I include my honorable judges, because a judge has to be a lawyer first before he becomes an honorable judge. Therefore, the legal community of this country, insofar as its legal acumen is concerned, and it gives me proud pleasure to tell you, many people feel that lawyers always tell lies. That's the normal perception of people. But if a lawyer is saying that as part of his advocacy, he's not telling a lie. He's not changing the facts. He's telling the judge what is the, that's exactly what I emphasize, that when you are making your plaint, disclose everything, yet disclose it in a way that you can turn it to yourself. Now, that's not telling lies. But yes, by coming into force of the Commercial Courts Act, our stature in the international market has certainly gone up.
Right. All right.
I only wish that this jurisdiction with respect to not only our 5-6 states like Delhi, Bombay, Calcutta, Madras, should have also gone to the high courts, especially maybe you could have changed the matter with respect to that, because the commercial courts must have acumen as a commercial man first. He must understand the problem, both lawyer and the judge. And that's where the principle of empathy comes in, that you must put yourself in that place of your client or the other side and see, what would you do? Now, therefore, it is necessary that we must all examine these issues of commercial world to see when commerce is taking, and with the economic setback that we have had or we are having today, we need to look at our commercial disputes in a much different way. Therefore, I said, as lawyer, as senior counsel or advocate on record or solicitor, we also need to look at it. Should we resolve, if it's possible for us to resolve? Can I give the other side a proposal which will resolve the matter? Maybe I use 12A or I don't use 12A. It's a different question that I've raised. But even in the court, I should be able to take that call first. And our international stature, I always say this, I at least do not find any well-meaning law firm in the world today which does not have an Indian lawyer. Everybody has an Indian lawyer, because as they say कि जुगाड़ कराना है तो Indian lawyer ही कर सकता है, कोई और नहीं कर सकता. So that is on the lighter part. But I think we have the great acumen.
Yes.
When I came to the bar, I must share with my young friends. People used to come from the Supreme Court or from the Bombay High Court to do our matters. That's where we brought from 10 o'clock to 10:30 our starting, because then 10:30 Supreme Court also starts, and many people from the Supreme Court won't be able to come to Delhi High Court. One part. The second part we looked at is today, and I should be proud to tell you this. Today, Delhi lawyers are taken to Bombay on the original side to make their submissions. That's the stature that you people have acquired over the period of time. After coming into force of Commercial Courts Act, the way bar and the bench has performed, even on the arbitration take, for example, the disposal of arbitration cases under Section 34 will only be possible with the assistance of the court or the assistance of the lawyers. Therefore, you people have played a predominant role in every judgment that the judge passes, because the judgment actually speaks the quality of the judge, one, but it also speaks of the quality of the assistance that you have given to the judge. Because if the judge has got, and a famous judge of the Supreme Court, now UK, but of course at that time House of Lords, which we all talk of every day, he was sitting in the Court of Appeal when this Queen's Counsel had said, "Your Lordship had decided this issue as a commercial court." He said, "You did not assist me, my dear Williams. Had you assisted me, my view would have been different." Therefore, the assistance to the court is important. And though we certainly stand up to help our clients or whomsoever we are representing, but please keep in mind that if you are a resolution process or person who expeditiously gets the matters disposed of, I'm sure the country's head or the country's flag would fly much higher in the international world on the commerce side.
Shall we move on to the next question, sir?
Yeah. You can ask me. I can go on. I have no problem.
Yes, sir. Of course, sir. We look forward to hearing you, sir.
Yeah,
So,
please.
sir, as you mentioned that the IBC and commercial courts, we would prefer to call them something as modern laws. And, then there are laws that have not changed for 160 years, like the IPC. It has only worked through amendments. And what our question is that what aspects of law require these new modern acts for? And would you refer to these acts as modern laws, like IBC and Commercial Courts Act? And moreover, do you think that these acts are well drafted, just like the IPC, to stand the test of time?
Well, I must share that with you, Govind, that times are changing. And with the change of times, we'll have to change our laws. There's no doubt about that part. In commercial law, or for that matter, IBC, you mentioned both of them. In Commercial Courts Act, we brought an amendment. Notwithstanding that it was a commercial law, we thought if we can resolve these issues on commerce side to the satisfaction of both parties. That was why 12A was introduced in 2018. Therefore, the purpose of these are actually modern, fine, they are modern, but they are actually economic laws, where economics is playing a role. Therefore, what our great lawyers and stalwarts used to say, Mr. Sheetalwad, in one of his full court references, had said that a lawyer would read law 30%, should lead 70% outside law, because his knowledge of outside world is equally important for him to come to the conclusion, how does he assess the court? Therefore, it's necessary for us to examine. No law can be perfect. Change of times will come. In fact, IBC has been amended 4 times. The regulations even amended a few days ago, even during COVID times.
Yes.
So that is one legislation, also a great reform in economic reforms brought up by the government, because it is thought in India there was no resolution process ever considered. We had only to go in amalgamation, or we had to go to hive off, or we had to do that only under the old Companies Act 1926. But for the first time, if you invoke insolvency jurisdiction, which is again a commerce, a steel plant that we have seen those 12 big cases that the Reserve Bank of India referred to the insolvency, those are today in new hands. And to establish a steel industry, it will probably need 5 years or 10 years. But this industry was available. And with the new professional hands, you are actually making the economy to grow. You're making more employment for them. You're making more production for them. Therefore, no economic law for that matter can be static. To my mind, law is never static, whether it's economic or not economic. But more so, economic laws need change because economics change. Your world situation changes, how the world is reacting to you. Today, we have blocked many things from China. We do not know whether we'll get the opportunity to do that or not. Now, if we get that opportunity, if India becomes a hub for even mediation or arbitration or any commercial dispute, in view of the new development that has taken place, then I'm sure the law will have to be amended. For example, look at Singapore Convention. India is now signatory to Singapore Convention in 2019. It comes into operation on 12th of September 2020 because some countries have already ratified it. Now, by that, you don't need to go to court. A mediation settlement does not go under Section 89 or for that matter under 12A. You can have a mediation settlement, even cross-border mediation settlement, which can itself be a decree of the court and you can enforce it straight away. Now, see that change in economic law would come in. While if you are going to 12A, you might have to, it comes as an award for the time being in terms of Part 3 of the Conciliation Act or Arbitration Conciliation Act. But once that act of mediation comes into play and it looks into the position of Singapore Convention, then Part 3 will go or become redundant. That mediation settlement itself, because it's pre-compulsory, pre-mediation proceeding, that settlement itself will be enforceable as a decree. Now, obviously, there will be change in law. You'll have to amend your Commercial Courts Act. There's no choice about it. Therefore, the amendment is welcome. And I think that is why, if you see the history of this country, Article 21 as it's written in the Constitution is different.
Yes.
Article 21, what is interpreted today, is different.
Yes, yes, definitely. Yes, correct.
Therefore, by interpretative process also, the law is amended.
Yes.
It's expanded. You are looking at the intent of the legislature and therefore expanding its scope. Therefore, we all must look at how do we resolve by expansion. Where we need to restrict it, yes, we need to restrict it. I'm not saying no. The law certainly requires, if it is a penal provision, you just can't expand it to say, all right, if you sneeze also in the court, it's a penal provision.
Yes, sir.
Therefore, you'll have to make that choice. In a commercial world, it is important for us to have a disposal faster, whether by resolution or adjudication. But in a penal provision, of course, it's we find now cases, look at the judgment that Bombay High Court has given with respect to the fact who thought, we all said these people who had come for the Muslim League, something in Nizamuddin, had spread COVID. Look at that beautiful judgment the judge has written.
Yes.
Each word looks like to me as if he's speaking from his heart. He's as a human being. Therefore, he has looked at the problem from a human part.
Yes, sir.
And interpreted law in respect of that. Therefore, that is need of the hour today, both for the bench and the bar.
Definitely, sir.
And that is where you will need an amendment. And the amendment can come both ways. When you assist a court, look at yourself. 2005, we thought our girls and sisters and brothers, everybody has got right into the co-passionary property. Supreme Court changed its view.
Yes.
We've now got it restored in 2020. So it's interpretive process also which expands or restricts the law.
Definitely.
So therefore, it is necessary that we must look at institutions when we are building up. People who know or have practiced law must be requested to give up that few thousand crores that they have in their pocket,
Yes, sir.
a few hundred crores, a few hundred rupees, whatever you may call it, and go to the bench because the need of the hour of this nation is how do we build an institution? And building an institution will only come when youngsters like you will take up those opportunities, take up those responsibilities to stand on the other side and dispense justice.
Thank you, sir. So thank you, sir. We definitely will. Sir, a question we'd like to ask you is that we've all heard about you, sir. Whenever you get into law school, I'm not kidding, the first year, one of the first names you hear is yours, sir. We hear you throughout my law school. Then it's a pleasure to be here with you, sir, today talking to you one-on-one. So just from your point of view, sir, a lot of people want to know, what was the first case that you really was big for you, sir, that you thought it was something different, and you have, as we say today, arrived as a lawyer, sir? What was the first case you would say, sir, in your personal experience?
Well, I may not be able to pinpoint my first case to you, but I can only tell you this, that I don't think I did law to become a lawyer. I belong to a business family, and I thought especially Punjabis, the moment you graduate, your next step is marriage.
Yes, sir. Yes.
And I did not want to get married at that early age. And I was certainly interested because I was the prime minister in my school, and then became president of the law union in my college in my undergraduation. So I was looking at the university position. So law was the opportunity that I could get.
Oh.
But the first year itself of law changed my concept.
Oh,
I think the teachers imbibed into you the strength to look at. And that's why I say it's the lawyer profession which can innovate. It's the lawyer's profession, lawyer alone or the judges alone can innovate new principles from the same statutory provision.
Yes.
Same provision. You apply to A facts in a different way and B facts to a different way.
Yes, sir.
It's only this profession that can do it. Otherwise, he will say, "Pet mein dard hai, to ye dawai khani hai."
Yes, sir.
See? But
yes.
Today, as a lawyer, the same provision you will stand up in court and interpret, and there's no estoppel against you,
Yes.
because in the last case you heard it differently. But I certainly remember that I was still with my senior, and what you have is South Indian restaurant now on Janpath, which sells South Indian food. There used to be a firm called Delhi Motorcycle Company, which
Yes.
used to sell ambassador cars.
Yes, sir. Yes, sir.
And there was a dispute between the partners, and that dispute was in court. And we had moved an application for receivership. And of course, one of the things that I wanted to share with my friends was that one of the things that was taught to me and I learned was, never think that you're a junior, you will not get an opportunity. Read your file as if you are going to lead the matter. And if you get that opportunity, please take it. Don't be scared about it. Doesn't matter even if you fumble or do something, there's no problem about it. And this receivership application, my senior was stuck in the High Court and I was in the district court. I'm talking about a district judge. And he said, choices, either I dismiss it or you start. So I started.
Okay.
My senior had come and looking at me, he sat down for some time in the court. I didn't know because I was facing the honorable judge. He came from behind and left the court. And I went back thinking that he never came. He could not make it. So I went back to the office, said the judge was not agreeing. And therefore I had to argue the matter. And I thought that probably I'll be chucked out on the same evening. But I still have that check with me. My senior gave me 220 rupees to say, you did a remarkable job. And that his words actually came true when the district judge actually appointed a receiver. So that was the beginning to give you an encouragement. And I think for each one of us, every matter should be an encouragement. Every matter should be a learning process, because every day the new matter coming to you must imbibe in you something new enthusiasm to look at that case differently than what somebody else will look at. And if you look at that, that's your landmark situation. But yes, to give you much later in life, if you remember, High Court jurisdiction was very less under Section 5.
Yes, yes.
First time it was enhanced to 50,000 rupees.
Yes.
And I was then also the president of the bar and I challenged it.
Yes.
Because that amendment was brought about by Delhi government. I did not get the interim order, with the result that the jurisdiction started going to the district courts. However, on the second or third hearing, the bench thought it was a larger question that I'm raising and constituted a 5 judges bench. So that amendment came before 5 judges bench. This case reported in Gitika Panwar, sorry. And it came with a judgment at 5-0. That means unanimous decision came that Delhi government or Delhi Legislative Assembly had no jurisdiction to amend Delhi High Court Act. And I had tears in my eyes standing, listening to that judgment. So these are tears to look at, that somebody else has patted you at the back, where many of us thought that no, what is there? Government of Delhi is assembly under 239 capital A is entitled to. Delhi High Court looks at all its financial dealings with from Delhi administration, everything, or then Delhi government, then why should it not have the right, even if it's limited? But however, fortunately for us, that the 5-0 bench accepted it, and the amendment actually came later from the government of India, and that's where the Supreme Court became infructuous. But that principle still remains.
Yes.
Therefore, as lawyers, you have to understand the judgment which I referred to about the Honorable Chief Justice, Justice Geeta Mittal. His Lordship was not Chief Justice at that time. We as lawyers have nothing to do with court fees, but we challenged it.
Yes, sir.
And that judgment came in United States, Cornell Universities, one of the best judgments of the world.
Yes, sir. It has
That was rewarded. So therefore, we must look at opportunity when we get.
Yes, sir.
Don't lose that opportunity, whether you are on your own, whether you are in a law firm, or you're with somebody else. Look for that opportunity and grab it.
Thank you, sir. Sir, thank you. Thank you for your precious time, sir. Just with one parting word before we have the vote of thanks. Any advice for young lawyers, sir, with the changing scenario? Any one or two in your lines, sir? Any activities we can do to enhance our voice, because, or any way of researching we can do, sir? Just beyond that, then there'll be a vote of thanks by Janvi Sharma.
Okay.
So I just your word.
I have only to request you all to, first of all, I'm sure all of you are gentlemen, great human beings. I have no doubt in my mind. And I can share you, people always thought, and I also thought, that we have lost our human talent, but no. My experience at the bar tells me we all are still human beings. Therefore, the first condition for becoming a lawyer has to be that you have to be an excellent human being. Then, as I said, a lawyer must get wedded. He is the one who always commits adultery, though technically. So he must get wedded to his profession before he gets married somewhere else. So if you're wedded to your profession, you will read your brief well. You will not go to the computer to see SCC online. You will see what are your facts and how will you interpret that facts. And then see if Justice A or Justice B supports you or goes against you.
Yeah.
Because if you go there, because normally what is happening today is, with all my humility, we give a proposition to somebody, we just go to the computer, read 2 lines and say, here is the judgment, sir. No. For a lawyer, it is necessary that we must adopt something new, innovate. That's what I said. There's the only profession where you can think new. The same provision in the facts can become different. And look at the first principles of law is this third part. And let me give you on a lighter vein an answer to that. I had a Chief Justice in Delhi High Court called Justice Varyava. You all know he went to Supreme Court.
Yes.
I knew Justice Varyava, I never knew that he's going to become. He was a lawyer in Bombay High Court. And we used to work together. We have gone to international conferences together. We knew each other very well. I didn't know he'll become a judge and then come to Delhi High Court as Chief Justice. And then I'll be the president of the bar. So I go up to him one evening to say something which was very urgent for me, according to me. He said, no, sorry, I can't hear you today. I will not talk to you today because I have to interview your friends who are becoming additional district judges. And they're lawyers waiting in the lounge. So I said, but this is very important because that will require your attention after that meeting. So I'm just bringing it to your notice. Give me 10 minutes. I won't have coffee with you today. So anyways, to cut this story short, he said on one condition, you will give me 2 questions, which I must ask your friends when I'm interviewing them. So I gave those 2 questions. And those 2 questions were that I am coming to High Court to file my suit on the last day of limitation. Or my clerk is coming. He meets an accident on the way. So he's in hospital. Suit is not filed. What is the remedy once he comes to know that suit could not be filed? For that litigant or for that lawyer? I'll give the answer later. I asked him another question to ask them. When is Order 10 statement made in court relevant? So he calls me up at 9:30 at night to say, out of 39 people that they interviewed, 38 said we don't have the answer. And one man answered and answered wrongly. He said Section 5 of the Limitation Act will apply. Now, these are fundamental principles. If we understand them, we will not go wrong. And if we don't go wrong, no judge can pinpoint anything to you. And go with this spirit in your mind, you will bring something new to the judge, because he must also tingle in his mind, is somebody coming to me. When you enter that courtroom, the judge might say, God, Janvi aa gayi. आज कोई प्रॉब्लम आ गई, गोविंद आ गया, आज कोई नई चीज आएगी, आज नंदा साहब आ गए, आज देखना कोई नई चीज दिखाएंगे. If you get that spirit, that perception around you,
Yes, sir.
I can assure you, your success is no problem at all.
Thank you for those kind and humble and wise words. I'll hand over the mic to Janvi Sharma.
Thank you, thank you.
Thank you so much, sir, for that enlightening session. You have made all our Sundays. I would like to thank you firstly for taking out time. I know you have
No, there's no problem.
you have a very busy schedule and you took out time for all of us, and we are very humbled for that. We are very happy that we could kick off the Lawyers Wit lecture series with your webinar as the first one of the season. So it was very interesting.
That be first one can also be the, minus. You start from minus, then you go to the 100%.
No, sir, I think we're starting from 100 and going to 200. And also, sir, thank you so much for teaching us on the interplay between commercial courts, mediation, pre-litigation mediation, the intricacies of civil law and commercial courts, and how a lawyer may get stuck on certain technicalities of civil procedure, which many a times we just overlook. Like you said that the last 2 questions that you asked, it's right there in front of us, but we may not see it because we don't focus on the details, which is very important for any budding lawyer. So I think today all the attendees, be it law students, be it lawyers, be it laymen, I think all of them have gained a lot from your session. I would like to thank you on behalf of Latest Laws, Divyanshu. I would like to thank you on behalf of Lawyers Wit and Tarveer Singh Nanda. I would like to thank you on behalf of Virtual Lawyer. And I would also like to thank the team that has helped us. That includes Govind Chaturvedi, our moderator, Paritosh, who's helping us. He's also managing YouTube and Facebook comments and, making sure all the questions reach us on time. And of course, Tarveen, I'll now hand it over to you to give the last 1 or 2 lines before we end the session. Thank you so much, sir.
Thank you. Thank you so much. Play my regards to everybody at home.
Hanji.
So thank you so much for this wonderful webinar. Thank you for enlightening us all with your knowledge and wisdom on this particular subject. And so particularly, I would like to congratulate you on becoming the president of Bar Association of India.
No, I'm only president-elect, boss. I'm not the president. I'm the president-elect.
I apologize.
Because the only good thing is that you are today looking at a position which was once held by Mr. Sheetalwad and Mr. Fali Nariman. And that's the honor that I feel that I've got. And that also unanimously. I think that's because of your prayers, your help, your support, and of course, grace of God.
And I would also like to make a mention that whenever we seek any sort of assistance from sir or we would request sir anytime. Sir is always there to help all the juniors, all the budding lawyers. So I would, on behalf of all the team, I would like to thank you for this wonderful session, sir. Thank you so much, sir.
Thank you so much. Thank you, everybody. Thank you, participant. Thank you, Janvi. Thank you, Tanveer. Thank you, Mr. Govind. God
Thank
bless
you.
you. Have a great Sunday. Bye.
Thank you.
Thank
Sir, thank you so much, sir.